is a security that is held or safe kept on the blockchain equivalent to a security in a normal securities account?
Yeah, well, it very much is. And
does that mean that I still need a TA on top of the control agent?
The simple answer is no.
If we issue shares, for example, under this new blockchain 4 law, are we ready to enter a secondary market?
For me, it's absolutely possible.
Hi, everybody. Welcome to Final Block, our fun tokenization podcast series. My name is Bock from Invest3, and today, as announced last time, I have a guest, Raoul Heinen from Linklaters. Raoul is a partner at Linklaters. He specialized in anything which is fund and fund legislation as well as regulatory matters. But more importantly, he also understands blockchain and knows to make the interaction between blockchain and legal topics. Welcome, Raoul.
Thank you very much for having me.
So let's maybe go right ahead into the heart of the topic. We have blockchain 4 law, but that means we had blockchain 1, 2, 3. Could you just briefly introduce again what 1, 2, 3 said before we move over to 4?
Okay, I will try to keep it concise because it's always difficult, these topics. So if we go back, Luxembourg did have a bit of advance on other jurisdictions in that sense that we did do this for a number of years. So it started with the first blockchain law. First blockchain law officially recognized the possibility to keep securities accounts. So those would be those, for example, that a custodian keeps for its clients. And it recognized the possibility to keep them in a DLT-based environment. So that was the very first thing. Why is that important? Quite simply because it allowed to register ownership and transfer ownership in a fully DLT-based environment. Second law was around changing the Luxembourg dematerialization law. What happened here? Basically, the law clarified that the securities issuance account, so that's when you issue dematerialized securities, that can be kept using a DLT-based environment. So that was very much for the very first time that we saw the possibility to issue securities ab initio in dematerialized form, but using a DLT-based environment. That worked quite well for bonds, so for debt security. So we did see a number of very high-profile issuances, but there were a number of drawbacks for equity securities, including funds. And that is ultimately what led to blockchain law 4, but we'll get back to that, of course, later.
Yes, but before we go into the blockchain 4, let me ask you a question which I usually get quite a lot when we operate and when we speak with asset managers. Is this question, is a security that is held or safe kept on the blockchain equivalent to a security in a normal securities account?
Yeah, well, it very much is. And actually, we also, now again, going back to what you said previously, we all, of course, saw a third blockchain law, and that law very much said that, well, security, financial instruments, which is based in a DLT-based environment, is the absolute equivalent to a financial security under MiFID, and so it is exactly the same.
So, I think that is already a very important myth to be killed, because there's still a certain suspicion that this is different. It is not. It is fully.
We hear it regularly.
It's a classic one. So as long as you keep this whole thing under Luxembourg blockchain laws, well, it's absolutely equivalent. There is no differentiation. So let's then move a little bit into blockchain 4 law. And if you would give us an entrance in what did it really do, or what does it really say?
Yeah. So I think what's really interesting is that this is, for me, very much a law which had blockchain thinking, which had technological thinking at heart when it was drafted. And when you read it, you can very much see that. What does it do? It basically creates a completely new regime for issuing dematerialized securities in a DLT-based environment. So I, of course, talked about that before, but this is basically an improved regime, so a 2.0 regime of what we had before. How does it work? It involves a new concept, the concept of a control agent. Control agent, to keep it short, has sort of a threefold mission. First of all, it keeps the securities issuance account in DLT-based environment. It has also the oversight of the holding chain in a DLT-based environment. And then just to make sure that things actually work, it needs to reconcile, needs to check that the number of securities in the issuance account are equivalent to those in circulation, basically, and those recorded in securities accounts.
Okay, so then let's maybe dive just a little bit like, this function usually reserved to CSDs or TAs? How does this control agent law now work with these two kind of players?
Yeah, that's I think for me is one of the most important points about the new law, because I mentioned we previously had something which didn't really work. So why didn't it work? Quite simply, before we needed a settlement organization, a central account keeper to support the issuance. Well, in Luxembourg, we don't have a lot of these entities. They're very highly regulated, so not an easy one to get. And most of all, there were no real service providers that were available to support it. So even though it was possible theoretically, in practice, it didn't really happen. And this all changes with the control agent, because the control agent can be a settlement organization, but it can also be a credit institution, a MiFID investment firm based in Luxembourg, or, and very importantly, that's an interesting point as well, based abroad but passported into Luxembourg. Mm-hmm. And why is that really interesting? Well, quite simply, it increases the pool of service providers that are available to support the issuance of tokenized shares. And also, for me, it increases innovation as well at the same time. Yeah. So we really have a true alternative to this TA-based tokenization model, which I find really, really interesting.
Yeah. So maybe also the question that I usually get, and I guess you also have already got several times, does that mean that I still need a TA on top of the control agent?
Well, a question we get very, very, very much and very often. The simple answer is no. There was also a conference organized by ALFI where I think that there were some confirmations by the regulator that was indeed the case. So the simple answer is no. Of course, I think that the devil lies in the details. So we'll have to see if the existing regulatory regime doesn't need to be adjusted a little bit. But theoretically speaking, no need for both a control agent and a TA.
Yeah, but I think that's also, and then the draft law, the commentaries to the law also specifies that a little bit by drawing the attention to this. And you have also mentioned it. This is really the first time that the technology is embraced into law. Yeah. Why do I say that? Because under the old kind of frameworks, we had this double layer of in the system, which was the issuing exercise, and then from the issuing exercise to the distribution exercise via the TA and the mirroring of the accounts, and that is now gone with the control agent law.
Yeah, exactly. Yeah, it's a little bit technical, but essentially, if you look at the old regime, really, what a custodian, for example, that kept accounts for its client needed to have, it needed to have an account with the central account keeper. So a first account, then it needed to have an account for its ultimate clients. And in reality, how it very often worked is that it kept an account for another custodian, and there was a chain of I'm not saying hundreds, but of tens of custodians down the chain. What is new under the law is that the law really provides for the possibility for a custodian, for an investor, to have a securities account directly in the DLT-based environment controlled by the control agent, which is, of course, a huge step because it simplifies, it streamlines the holding chain significantly. And it also enables the possibility, for example, for an investor to self-custody its own financial instruments, which we're not there yet, but it is a possibility, and the regime is very, very advanced in that respect.
Yes, absolutely. The other thing I think that is very interesting, and you mentioned it, this series of account that was needed, that would be completely released. There is just, instead of having multiple records, you have one single record on the blockchain, which is then orchestrated through the control agent. Correct. And the control agent is the guarantor that this whole thing is working. And so very interesting. So do I understand it correctly? So it's basically the control agent that gets a direct mandate from the fund to run is issuing account. That's what it really is. That
is exactly what it is. It's sounds simple. It's a little bit more complicated, but that's what it is. Yeah.
Okay. And then something which I guess you have already started to have certain reflection. And I wanted to see whether you can share some of us with us is. It also states that it's up to the control agent to orchestrate the legal framework a bit. I mean, it is like, okay, it has to establish a legal framework that would connect the fund to the safekeeper and to the investor. While if you're on self-custody, directly the investor and the issuer. Do you have already ideas around such a framework and what could be like the key aspects to watch?
Well, I think probably two things, if I think about it a little bit. I think it obviously needs good agreements between the fund, the control agent, and any other party that will be needing to have access to the information in the DLT. So that requires a bit of contractual drafting, a little bit of attention to detail, the stuff we do, but clients don't like to take care of. And then the second layer for me, which is important, is the actual smart code, which governs the whole thing. Because I think under Luxembourg law, obviously, like under any law, there is a certain number of requirements which are attached to the securities that are issued. As an investor, I need to be able to have a look at any time whether I am indeed the owner. For example, if I want to pledge my securities, the bank needs to be able to record that in the account to mark that the securities are pledged. All of those legal requirements need to be embedded into the smart code. So that is for me the part which requires a little bit of thinking. But the good thing is, I mean, there's a number of actors on the Luxembourg market, you being one of them, and there's a lot of experience, there's a lot of thinking already that went into that. So besides checking whether everything actually works, I think a lot of thinking is already in the smart code. So it should be a mere formality in reality.
Raoul, maybe what I also wanted to touch slightly is the difference between native and non-native fund tokens, because very often people have some trouble to make the difference between both of them. Could you give us a little bit of a differentiation between a native and a non-native fund token from a legal perspective?
Yeah, sure. So I think it's a question that preoccupies a lot of people, because I think in the market we talk a lot about a tokenized fund, but that generally encompasses everything. And for me, there's only one. The native one is the only true tokenized instrument. So what are we talking about? You can have a fund security which is issued in tokenized form. So using a control agent, using a digital TA. For me, that basically means that the token that is issued is the security, and it is legally speaking exactly the same. So when you own your token, you own the security. So that is for me the native, the ab initio fund share. Besides that, we saw over the years a number of experiments as well with people actually holding a position in traditional fund shares, and then what they did is tokenize sort of a claim right on the underlying shares and allow those tokens to circulate. The difference is here that the tokens that the investor has do not really constitute the actual fund share, so they don't really have the rights in the fund, in distributions, in voting rights embedded into it. It's merely a claim right on the underlying security. So it's a big difference, actually.
Yeah, so and there on that specific new issuances with the claim rights that you described is very often structuring to SPVs or similar, so really issue of a new right. I would then dare to add, nevertheless, a second non-native category. At least that's how I would still see it, and then you let me know whether you agree. I would say there is one non-native fund tokenization which reflects completely the same underlying security, and that's the reason or the situation whereby the fund is still issued by the TA. It still moves through this mirroring chain, for example, to a safekeeper. And if the safekeeper would decide that the legal binding record of ownership is a blockchain record that he issues for his client, I would still call that a token, while it is a non-native token, because it started in the normal old kind of paper form or electronic form of the issuance. Would you agree that we can also say that this specific, mainly safekeeping arrangement is also a kind of non-native fund tokens, and that in this case has exactly the same rights than the underlying security?
No, that I absolutely agree with you. Of course, no, that is true. But it's a small legal nuance. But yeah, I completely
so
agree.
Coming back on this on the other question where we say, well, we really want to be very clear on it. So let's be very clear in this specific situation where you say, okay, some people issue new rights via SPVs and new contracts. well, definitely the nature of the underlying arrangement has changed. Yeah. While if you just keep, you use, I think it's blockchain 3 or 2, you just use it to record ownership, then we would be in the same right situation.
Exactly, because the Luxembourg law says that if it's in the securities account for someone, that evidences ownership, and that's exactly what you were referring to before. Yeah.
So be careful. Yeah. So on non-native side, there's even more kind of differentiations to make, but under the Luxembourg law, you have the possibility to run the registration of pure ownership. Now, the other element I wanted to bring in, and because we promised our audience also to try to be as close to practical cases. So, and we have already some demands, and we have demands that say like, okay, can you please issue a tokenized share class for me out of my fund? What would you tell me? Is that possible? What do I have to consider?
I would say it's definitely possible. A couple of things to note. Here again, I think there's this distinction between, are you using a TA-based model, are you using a control agent-based model? TA-based model, it's possible for both, but TA-based model means basically that the TA has to be in the boat and the TA needs to support it. You cannot have at the moment a separate digital TA which takes care of that, which complicates things in practice a little bit, even though it's possible for a TA to run, let's say, a traditional register and a digital register side by side. With the control agent, I think what changes is that you could theoretically have also both systems running alongside without having this. Is it a TA? Is it not a TA? For me, it would be perfectly possible for a TA to operate with a control agent, for a model to operate only with a control agent, and to thus have a digital share class created like that. And by the way, for me, it's not really different from now creating a new sub-fund under an existing umbrella. Here, again, I would say it's possible to create a new tokenized sub-fund where other sub-funds are based on a traditional model. So all of that is possible, but of course it requires a little bit of tinkering also in the documentation that underlies the fund.
That's very interesting and very important to hear, because I think what we all want to achieve here is we want, I mean, this is a strategic advantage if a fund center makes that real life because of cost, because of redundancy of data, because of siloing that is not, or siloing that is broken on data, and so on, because of time frame for settlement that can be reduced, and with that the settlement risk can be reduced, all these kind of elements. And however, what is important is that we can have something like a gradual innovation process. It's not that you have to push the button and to change your entire billions of accounts that you have running. So you would absolutely confirm that a gradual step in the process is absolutely possible.
Absolutely. And to be honest, I think that's the only possibility to do it. I mean, you will not be able to convince a fund manager to convert the existing fund ranges from one day to the other to a digital equivalent of it. That will not be possible. So the only way to do it is to do it in a gradual way. And then ultimately, I think the digital model will prevail, quite simply because it will be more efficient, it will be less costly, quicker, etc. Everything that you said, but it will be a gradual process.
Yeah. So then I think one of the big topics, and of course, even if we speak about AIFs or LTIFs, one of the big topics, and one of the things where regulators have a little bit had their headache in the past, and for sure for an LTIF, is liquidity. How can I get liquidity to consumers, to investors? And the less liquid an asset is, the more restricted is the distribution element. Now, liquidity can, of course, be driven by tokenization. So if we issue shares, for example, under this new blockchain 4 law, are we ready to enter a secondary market?
Absolutely. For me, it's absolutely possible. As we said before, tokenized securities are the same as regular financial instruments under MiFID. Hence, they can be traded on the MTF on a trading platform. Of course, the important question is sort of, will the MTF still be an analog MTF, which is very much possible? Will it be in turn a DLT-based MTF, which must take into account a couple of additional rules. We have the DLT pilot regime to be seen where that leads us, whether we will see something more advanced in that respect, whether we will see something like the DLT pilot regime become the mainstream. But it is possible under any of these models, and it's important that it exists. Why? Maybe I can talk about the advantages of that as well in that context, because I think traditional alternative funds always had the problem is that usually you're locked up for a certain number of years. That means if you want to get out, well, you cannot really get out of the fund, but you would potentially be able to sell your shares to someone else on the secondary market. And having this DLT-based environment integrated into that, I think that facilitates this whole transferability of the shares enormously, and thereby it also reduces the strain on the liquidity at fund level. So for me, this whole retailization trend, need for additional liquidity, need for additional transferability, and DLT-based environments are actually a perfect match, and it's completely in line with the trend that we're currently seeing in the alternatives funds environment.
Yeah, absolutely. Because I think you're mentioning, this is the problem. A solution has always to fit regulatory framework, because we work in regulatory industry. And that's why the new laws that have now been coming and all the different kind of elements, as you have said, also DLT MTF sandbox is an element, but of course you can also have simply DLT MTFs, which is absolutely something that is running, will allow to act in this regulated framework in a proper way. I usually say, because I get from time to time some pushback with people that say like, but a token is not creating liquidity. I would fully agree, a token is not creating liquidity, but there will be no liquidity without tokenization. So that's my assumption. So, and then why is, and then you pointed it also out, it is simply because it is so dramatically cheap and efficient to run a secondary market in a regulated way.
Exactly.
And I think that's really a trigger that will make the whole situation change a bit. Now, if you do you dare to make a little bit of an outlook? How do you think things are developing? Where would you see first kickoffs? And I know you cannot speak about what you the request that you get right now, but maybe you can a little bit take an helicopter view on what do you feel the market does right now?
Yeah, I'm quite. I have to say I'm quite optimistic in that sense. I've been optimistic since a number of years. A couple of years ago, I think everything that we saw, everything that we did was very theoretical, of course. I mean, is it legally possible to do that? What do we need to take into consideration if we were to launch such a project? Now, over the past years, I think there's much more practical examples, which really makes me bullish on it, because there's not only people seeing if it's possible, but people are actually launching actual use cases. I mean, I cannot talk about a lot of things that I am working on, but we saw the Franklin Templeton tokenized usage, for example. That's public information that is running. We also have existing live cases where we have money market funds which are tokenized and which are then used as collateral in derivatives transactions. So all of that is live at the moment. All of it shows that it's actually working. So that I would see completely accelerate over the coming years, to be quite honest. I think whether it's in the alternatives world, I mentioned this retailization trend, I think there will be a need for tokenization as well, or whether it's in the context of money market funds, I think that will continue to be a growing trend. And that really reflects also when my interactions with clients, where there's more and more clients which are actually coming with me with a concrete project and say, okay, what do we need to do to make this work? How do we lay the groundworks for making this work? That is at the level of the actual fund or tokenized fund itself, but that is also at the level of, for example, trading platforms which would support the issuance of tokenized funds and which would support the tradability of the fund in question. So all in all, I think we're still not at a complete breakthrough moment where from today to tomorrow everybody will be issuing tokenized funds. But I would say over the coming years, more and more tokenized funds will be issued. And I would say even in 5-6 years, that it will represent a relatively sizable chunk of the market, to be quite honest.
Yeah, I'm a part of the fact that I always say I have a bet running, where that now like 2.5 years ago I said, half a year ago I said in 3 years, 60% or 2/3, 66% of all AIFs issued will be issued on DLT. So that's still a bet that I'm running for a bottle of wine. So let's see whether that is going to be true. Now I think there's one element not to be ignored. The US, they have now opened completely the gate with the Genius Act on entrance of tokenization into the financial space. I would say it like that because the Genius Act is mainly covering US dollar currency and the transfer. And then, of course, that is something which is interesting. And I would hope that the European rule makers are following now rather quickly, because what we should avoid is having another kind of SWIFT 2.0 which is dominated just by dollars. We need euros in our kind of frameworks to settle these transactions, and it would be really important just not to let it go. But one has to understand that if these guys are going, it's going fast.
No, exactly. No, I completely agree with you. For me, that is always... we're talking a lot about issuing funds, trading funds, but for me, another important limb of the whole puzzle is actually how do you settle? Do you settle with normal fiat currency? Do you settle with CBDC currency? Do you settle with tokenized bank deposits? For me, that is very important, because you cannot have a fully digital system where everything is semi-automated, instantaneous, but you still need to make a SWIFT transfer to pay for your fund share. So there, I think it's very important that the European legislator and by the way, I mean, we're having discussions with them on a regular basis. Also, there are exchanges on this topic. There is a lot of political will also behind it to actually make it happen. And why is it important? It's like you said. I mean, we cannot be completely dependent on the US dollar for the purpose of the system. So it's vital that we stay on the train.
Yeah, and also in your function and with your know-how, you're contributing to EFAMA, to ALFI, and to the industry in that kind of field. So last time we already had a bottle of wine on our table, and I told you I promised you I would reveal the secret of this bottle of wine. Now, what has a bottle of wine to do with tokenization, you might ask? Well, believe it or not, there is a connection between this wine and tokenization, and that's why I choose it. So it comes from my cellar. So the wine is called Clos du Paradis. The winemaker is Chateau Poquet, which is led by Abidur. So it's a Luxembourgish wine. And well, the Luxembourg wine tradition is, I would say, at least 200, 300 years old. And even in that region, even the Romans made wine. And the traditional way of Luxembourg winemaking is by making a single fermentation and then produce rather dry wine, sparkling kind of wines. And Abidur was the first one in Luxembourg that dared to experiment with an innovation, which was the second fermentation, which is based on malolactic fermentation. Malolactic fermentation is a fermentation that normally is used in the Burgundy, but also for most of the red wines, they have a second kind of fermentation. So, and he managed to produce a new kind of Luxembourgish wine, and just let's maybe pour it in first, taste it, and I'll tell you also one story about that wine, which is pretty funny.
I was very intrigued to see why the bottle is on the table. So it's good to...
So it was not only to drink it and have pleasure, but also to make this connection with innovation of a long-standing product, which our funds are established, well recognized, but dare to make it in a new way. So here we go. So let's...
Cheers.
Cheers. Very interesting, very nice. So you would confirm it's not a normal classical Luxembourgish wine?
It's not a normal classical Luxembourgish
wine. Let me tell you a story. In my former life, I was with some professionals on the one, all coming from around the world, really around the world, all mixed up, Asia, Latin America, and so on. And we made a Luxembourg wine tasting, or we made the wine tasting including Luxembourgish wines, but there were also some foreign wines. And so I was the only Luxembourgish person, so everybody wanted to have some information from me about Luxembourgish wine. So when I gave this information, and then it was all about blind tasting. So the first came in, we had a little bit of the discussion. The second came in, and we all agreed it would be French, me including the Luxembourgish guy. So well, that must be a French wine. And then the wine bottle was open, it was Luxembourgish, which I was then really embarrassed on. Just say, okay, I have no clue what my country can produce. So that's a little bit another story about Clos du Paradis and innovation that goes around. So what are your favorite wines? Do you have?
I like wines a lot, so it's always difficult to go for a specific one. But I do. But my wife is French, so I like French wines. But I'm also big about Italian reds. Lastly, this year we went to Slovenia to go with something a bit more experimental. We managed to taste quite a few Slovenian white wines, also macerated wines. I was very impressed by that. So that is the current new trend.
Yeah. So how would you rate, or what did you know Clos du Paradis?
I knew the winemaker, but I didn't know this specific wine. But I like it. It's indeed it's a little bit more sophisticated than certain other wines. So
Absolutely.
I do like it. Yeah.
So and if your wine are friend, and if your wife is French, you could always try to do the same trick than with me, like maybe pour her in, and maybe she believes this is Burgundy wine, and by the way, it's a Luxembourg Auxerrois grape.
We'll see how it goes.
So this closes our first session. Thanks again, Raoul, very much for all your input, all your knowledge that you shared. I'm sure our audience have really appreciated. Look forward for our next time. It sure will come because things go fast, as you have said. And remember, if you always want to be up to date, register, tell your friends that they should register. We will continue. Our next session will be with Dr. Erik Falk, and we will more focus on the first kind of introduction into DLT and blockchain technology for the fund industry, and what are the kind of language and vocabulary you should understand. So we will work on that. We will have another bottle of wine for sure. And remember, T+0 is knocking at your door.